important subject. Anyway, we have heard her just now, and we could seen that she is having experience in several various aspects of law, including mediation, arbitration, conciliation, etc., etc. Anyway, we are welcoming you, madam, to address us at this evening for the Kannur All India Lawyers Union Kannur District Committee. And we are also welcoming all other persons who are interested in this platform to hear her. And for and on behalf of myself and my All India Lawyers Union, I welcome all of you. Thank you.
Thank you. Thank you so much. A very good evening to all of you all. It is really a very proud privilege. And I need to thank my friend Tankanji for literally forcing me to do this session, but I'm so looking forward to it. Uh, Learning is a sharing experience after a certain age. I learn from you, and I will just try and share whatever little knowledge I have about this topic. So, this is Sunday afternoon siesta time after a heavy lunch. So, you are all cheating on your sleep time or siesta time. And hopefully, I am not prosecuted for it because I cannot be. So, on that note, so we know the topic today is cheating. Cheating is in the chapter 17 of the Indian Penal Code 1860. Cheating is a very generic term and is just very casually used. He, she is a cheater. And I think we all must have learned this word when we were still in our young age, infancy, in the school. When somebody were to say, "Ma'am, she is cheating," or "He is cheating my paper," a report card is sent home. Your child was caught cheating in exam. So the word cheating has been ingrained since our childhood, that this is something which is wrong. Even as a cheating in exam, there is a punishment. That means cheating always, cheating which is done and which is caught. First is cheating has to be caught. So cheating, when it is done, there is some kind of a punishment, a reprimand, or whatever. So, on that note, let's first go to the basic sections of the same, starting with 415, which defines, gives a definition and illustration of the cheating. We go on till section 420. Now, we must have seen in the movies or even by the roadside, people say, "Oh, he's a 420." Means he's a cheater. That word 420, section 420, is used so very often by even normal people that everybody is aware that there is a section. They may not know the implications that the poor person has done a simple cheating which is covered under 417 and not 420, which is a much, much graver offense, same being liable for more punishment. But it's just generally used. When somebody says that person is a 420, we realize ourselves he or she is a cheater. So on that note, I would first like to begin like a lawyer by reading up the section 415. Though we might have read it many times, I will avoid the illustrations, of course, because that will be a lot of time consuming. And since everybody on this platform is primarily is a lawyer, we all would know. But still, going by the reading of the section 415, so it is very clear cut. Whoever, by deceiving any person fraudulently or dishonestly, induces the person so deceived to deliver any property to any person, or to consent that any person shall retain any property or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, or property, is said to cheat. There is an explanation to the main section, which is a dishonest concealment of facts is a deception within the meaning of this section. So it is not only merely property, but the section also defines that if in case there is a dishonest concealment of facts, that deception is within the meaning of the section of cheating. Now, if we were to actually go by the basic ingredients which are numbered and stated in the section, because when you give a clear cut reading as youngsters or maybe just beginners in the field of law, we just read it, we give it a cursory reading. But then, what are the basic ingredients? The basic first ingredient of this section is deception. There is a mens rea. There, that is most important. Now, without any thought or without any other uh, inherent dis- dishonest intention to induce a person, every act cannot be covered under the section of cheating and would not definitely call in for a criminal prosecution. So, to say that there is deception, then the same deception by any person or of any person, there is another ingredient which is fraudulently or dishonestly inducing that person. The inducement has to be two reasons, either to deliver any property or any other thing, or second is to consent to something which that by that person may rightfully or wrongfully retain a property which is not his. Now, with this, I would just like to say that cheating is very different from extortion. When we say cheating, cheating is by deception, extortion is by intimidation. There is a clear cut demarcation. We might feel it is overlapping, but when we say that the person is induced fraudulently to retain or to omit to do an act, then that sometimes people get confused. Even we have learned with experience that cheating and extortion are two different sets. So then, when there is a breach of contract, in case of a breach of contract, the same is very different from cheating. There is a very fine line, it's a thin line, but the distinction is such that a breach of contract cannot give rise to criminal prosecution. But if there is a intention, there is a dishonest intention and a fraudulent intention, which is there at the very beginning of the transaction, then that by itself, you are criminally liable to be prosecuted. I would like to give an example here. Let's say that I have a house in Kerala. I have a house in, say, Kochi. And I ask one of the person over there that my house needs to be painted. Can you do this work for me? We get into a contract. Now he gets into a contract, but he keeps asking me for the money and is not doing it. And every time I call up, because it's far and I cannot be traveling every day, so I ask whether my house has been painted, how much work is left, what all has happened. And he keeps on telling me, oh, I have done this, I have used the paint, I am doing renovation work in the kitchen. whereas nothing is happening. So from the very onset, the intention is to cheat. Why? Because I cannot travel down there. He's asking me for money and I'm transferring the money, but he's not doing anything. Same example. I get into a contract, the contractor does some work, part work is done, some payments are due. He asks me for the money. I send the payment, which is almost same, and then he realizes that I don't have to do this work. So that is just a breach of contract. Example is similar, but there the intention from the very beginning was not to do any work and cheat me. Here, it's a breach of contract because the contractor realized that over a time period, this contract is not giving me ample profits. So he leaves it. So the demarcation between the fine line has to be understood that every act, every omission is not liable for criminal prosecution. So it is like to be understood by the courts, and it is very well settled law that the dishonest intention at the time of making the promise is a sine qua non for the offense of cheating. That is the crux of this particular section. Now, there are lots of sections which overlap. Cheating and criminal breach of trust and criminal misappropriation. Now, I would just like to mention there is this very famous case of Casey Thomas versus A. Verghese. This is 1974 Criminal Law Journal, 207 Kerala. So it is very well discussed in that case that the criminal breach of trust is different from cheating. Criminal breach of trust is attracted when the person comes into possession of a property and retains it or converts it to his own use against the terms of the contract. So there is that criminal misappropriation. That is not necessarily, it may attract the consequences which are there in the section pertaining to cheating. Now, deception is very necessary for cheating to be established. The cheating has to have this clear cut intention which has to be there. Property, when we talk of property under the section of cheating, then every property may not have pecuniary value, but then the same has value in terms to attract the provisions of the section. When I talk of this, I would again like to give an example. There is this person who obtains multiple passports by giving wrong information to the authorities. Now, passport per se has no pecuniary value, but still it is property. It is property in the terms of the section to attract the provisions for criminal prosecution, because we as citizens of a particular country cannot have multiple passports. So we are cheating the authorities to obtain them. This was discussed in N.M. Chakravarti, which is settled in AIR 1977, Supreme Court 1174. Then there is definitely, when we call of cheating, and as I had started, that cheating can be cheating in exam, emotional cheating, cheating for a small little cause, telling a wrong time, cheating on somebody's time, cheating somebody's emotions. But there is that's where the distinction lies. There is a clear cut distinction between civil and a criminal law. There is a very thin line which overlaps, like, where a civil dispute of a commercial transaction, then if it contains a criminal offense, it becomes cheating. But if it does not, then it is not cheating. So we have to clearly understand the ingredients which have been stated so very specifically in the section 415, that cheating is only attracted when at the very inception, at the very beginning, there is an intention, there is a clear cut mens rea to fraudulently and dishonestly. The word dishonestly and fraudulently are described in section 24 and 25 of the Act of the IPC itself. If it is required, I can just read out the section 24 and 25, though I can just give you a quick reading of the section 24 and 25. Because that is clearly explains the word dishonestly and fraudulently. As students, we used to find these words so very difficult that it was like every section was so difficult. Now, section 24 says, whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. And section 25 says a person is said to do a thing fraudulently if he does that thing with the intention to defraud, but not otherwise. So, there the clear cut demarcation has been stated therein also, that there has to be a specific intention. Now, when we go further and we see that what are the various types of cheating which can happen, then you must have heard of cases of a person pretending to be a doctor and treating patients as a medical officer in a certain institute or opening up a clinic. In fact, even in our own profession, we have seen cases where people have been caught who have been practicing as lawyers without being certified advocates. They are not advocates, but they are practicing. So that is cheating by personation. So that is covered under section 416. If I could just read the section out for you people. A person is said to cheat by personation if he cheats by pretending to be some other person or by knowingly substituting one person for another or representing that he or any other person is a person other than he or such other person really is. The offense, the explanation to the section says, the offense is committed whether the individual personated is real or even an imaginary person. So here it is very clear that a person who is not entitled, like we have seen so many times, even in the movies. There was this movie which was based on real life incident. It is a Hindi movie, Special Chabbis. So there is a team of people, a team of people who pretends to be from the income tax and the excise department, and they conduct raids on people, and they were procuring from them their goods and their values, and they were not entitled to be. They had this whole setup, and people relied that they are income tax officers. Now there is this very famous case where a person went to the railway station and he pretended to be a railway officer to avoid ticket, and then also took up a room for rent and he stayed over there. Now by this, it is there is also again an overlapping even in section 416. Now 416 is cheating by personation, but if that cheating is done by a public servant, then that attracts section 170 of the Act. So cheating by personation is there, but then there is a specific section which is 170. If I may just read out the section for. So 170 states, whoever pretends to hold any particular office as a public servant, knowing that he does not hold such office, or falsely personates any other person holding such office, and in such assumed character does or attempts to do any act under color of such office, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Now, when there is in this section 416, the ingredients of this section are that there is a pretension by a person to be some other person. It is like today, I I can just pretend, if I were to pretend that no, I am not a lawyer, but I am some judicial officer. You are not going to seek my certificates that kindly show how you are. And there are so many judicial officers. I mean, obviously, High Court and Supreme Court judges are more known, but district courts, trial court judges. And if I were to pretend I am personating, so there, that example is so relevant, because in small towns, people, they do give a lot of importance, and people do pretend because they want to gain the importance and want to gain the benefit by impersonating. Now, the whole reason of personating another person is to gain some kind of reward, to dishonestly induce another person. If I were to pretend that I am a senior IAS officer to a shopkeeper, maybe I move into a new residence and I just inform the local person over there, the local grocery mart or anywhere, that I've just moved in and I'm this bureaucrat and I'm an IAS officer. So this is my food article, you send it and I will pay. The very reason I am personating as a bureaucrat is because I want to gain the benefit. I want free groceries. So my intention is from the very onset is to cheat. So this section will be attracted and I will be prosecuted for personation and for getting benefit out of it. Now, whether that person is real or not is also to be seen. Now, if I were to give an example, that there is this lady who might be similar to my age and maybe had some property in Goa, and she has some, and I happen to know her. I just happen to know her because she's in a group of friends. So she passes away, and I go to Goa and I pretend to be that female, say XYZ is her name, and I tell the neighbors that I am XYZ because they have never seen XYZ, and take away all the furniture because I cannot own the property. But since I have the key because she is my friend, I open her house, take away all the belongings, pretending to be her to the neighbors. So the intention is already begun. My act from inception is to cheat. I have personated myself to be the XYZ lady, go to Goa, get all the belongings out of her house and sell it or keep it or whatever. So I have actually induced the neighbors to believe that I am XYZ. They do not report to the police and I take away. So that, besides being theft, is also I'm personating, I'm cheating. Theft would be secondary because I have taken away, but I have induced the neighbors also that I am XYZ and I have come after a long time. So there goes. Thereafter, if we go to the further section of section 417, whoever cheats shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. Now, when we talk of cheating 415, both the ingredients are mentioned therein in the section 415. There are 6 illustrations to the same section, section 415. If we were to go back, there are, yeah, there is illustration till I, 7. So now the various illustrations are given to see the difference between a case of simple cheating, which is punishable under 417, punishment by personation, which is 416, is governed by section 4119, and 420 is a section which is of a graver offense. Why? Because it has got a serious implication. Now, as we go further, we'll just go through that. Presently, as I read, that 417. Now, section 417 is for simple cases of cheating. How the difference lies is that there is this fruit seller, and I want to venture into a new business of, say, opening a store where I sell vegetables and fruit. So I get in touch with a fruit vendor and I ask him that, if you, how much would you send me, say, I want to buy a whole lot of oranges, and what is the price range? And he shows me the different varieties, and I choose the best variety. And I tell him, all right, this is how much I want. I want 10 kgs of this variety, and you kindly send it to me in 2 days. Now that man says perfectly fine, takes the money for the best quality of oranges. At that point of time, that fruit wholesaler, his intention is not to cheat me, but because of some reason he's not able to get that lot and he gets a little lesser lot. So he sends me a little substandard, not bad quality, but a little cheaper. But he does not inform me of the same. Why? Because he feels that he will lose out on a business deal. So there, the offense is covered under 417. Same example, I go to the fruit vendor. I ask him that, okay, this is the variety I want. He promises and assures me that, and induces me to buy not 10 but 20 kgs. Why? Because this is at a very good rate and I may not have get it at the same rate again. And so I am literally induced by his words and I pay him. Whereas his intention is not even to send 1 kg, forget 20 kgs. So there the intention was to cheat me and to make me part with more money. So there section 420 will be attracted, which is a more graver and would attract more severe penal prosecution. Now, further, if we go basically to read the sections first, section 418 again says that whoever cheats with the knowledge that he is likely thereby to cause wrongful loss to a person whose interest in the transaction to which the cheating relates, he was bound either by law or by legal contract to protect, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Now, section 418 makes it very, very clear cut that the essential ingredient, again, I would repeat myself, is mens rea. That there is knowledge that he is likely, thereby he is cheating, he is likely to cause wrongful loss. Now it is there are so many examples which are there, that there is this man, we would have seen it so many of, it's often repeated in the movies, that it's really become like, sometimes when we watch movies, we can actually feel that, oh, this is going to come, that there is this man who's a very busy person, and he's got no time for basic, to see the regular documents which he signs. So his PS, the secretary comes and gets the paper signed. Now the secretary has an evil mind, so she just places another paper, or different kinds of, say, checkbooks, which she has to make the payment to people. So what she'll do is, she'll get another, he will not check the all the numbers which are written on the check. Now of course there are online transactions, so the times have changed, but let's presume that the checkbooks are there, and one is to the stationer, one is to the electricity department, to the phone line, blah blah, there are multiple checks, and one is a blank check, which later on that secretary wants to fill his or her name. So this man who is so busy will just lift a little bit of the checkbook and keep on signing without realizing that there is another one. So the intention and the knowledge was there, that now that I'm getting this blank check signed, I am causing a wrongful loss to that person. So that secretary was not entitled, but the intention was there. So the mens rea began. As I stated, that when we talk of personation under section 419, then that is punishable under section 4119. Section 4119 is very clear. Whoever cheats by personation shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. That I had already stated earlier on also, that the overlapping is there with section 170, which clearly demarcates between a general personation and personation by any personality as a public servant. So when there is a public servant, a person has is there is a specific offense under section 170 where one pretends to be a public servant, that has all the ingredients of cheating of personation, and the same are covered under section 419. Now, having come so far, the main section, which is actually uh, considered by everyone and stated generally also, 420, the most notorious section, 420, we come to that. So section 420 again states, whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person, or to make, alter, or destroy the whole or any part of a valuable security, or anything which is signed or sealed, and which is capable of being converted into a valuable security, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Now, if I were to just go back, then there is a clear cut distinction between section 417, 418, and 420, 419 and 420. Now, section 417 states imprisonment up to 1 year, or fine, or both. It's non-cognizable, bailable, triable by any magistrate, and is compoundable by the person who got cheated. When we come to section 418, again, section 418 is different from section 420. Section 418 is also imprisonment up to 3 years or fine or both. It's non-cognizable, bailable, triable by any magistrate, compoundable by the person cheated with the permission of the court. When we come to section 419, which is the punishment for section 416 of personation, again, the punishment is 3 years or fine or both. But in the case of personation, it's cognizable but bailable by any magistrate and compoundable. But when we come to section 420, section 420 is a very, very serious offense. Section 420 attracts a punishment up to 7 years and also fine. It is cognizable, it's non-bailable, it is triable by magistrate of first class, but is compoundable by the person who's been cheated with the permission of the court. So once the offense is non-bailable, there the demarcation is clear-cut. An offense which is bailable is definitely less of a graver offense than an offense which is non-bailable. There is that ingredients are overlapping in all the sections of cheating. The section 420, how it is different from the previous section is that in section 420, there has to be property in addition to the intention. The property has to change hands. Therefore, it is a graver section than the previous section. The previous sections only talk of inducement and there is a deception. But in under section 420, there is this exchange of valuable property. So once there is that exchange of a valuable security, that attracts section 420. Now, there was this case wherein it was initially thought to be forgery, but then section 420 was attracted. That was in the case where property papers were got signed by inducing the person, by placing the same property papers into different set of papers and getting the signatures. Now, though the signatures were later on onto the other papers forged, but the first step was that there was in the mind the thought to cheat, and so the first paper of property was got signed in a bundle of other papers. So that, besides attracting the sections of forgery, also attracted the section of cheating. So cheating is by itself punishable. The cheating, the word by itself has a very large context. It is like there is this person who pretends to be somebody else to goes and casts a vote. Now, the object of passing of that person is to gain access and to rightfully wrongfully cause loss to somebody. So there has to be a knowing mindset, a substitution, and by that only there is this thing that yes, there is that person who has caused somebody cheating. If I were to go further, under section 420, then as I stated earlier, simple cheating is punishable under section 417. But here under section 420, there has to be property which is delivered. The property delivered is discussed in this case of Sonbhadra Coke Products versus State of UP, 1994, Criminal Law Journal, 657, Allahabad. Now, if we were to see that there is this another very important case of Nilai Ganeshan versus State of Tamil Nadu, 1991, Criminal Law Journal, 2157, Madras. There is this team of financiers who conspired together to give counterfeit currency to a builder. So the builder was induced into parting away with property. So the property exchanged hand and the counterfeit currency was there. So the intention was to cheat the builder.
Could you repeat
Another,
the citation? Could you repeat citation?
yeah, Nilai Ganeshan versus State of Tamil Nadu,
Yes.
1991, Criminal Law Journal, 2157,
Yes.
Madras.
Yes.
There are a few more citations which are important for this. One is a famous case of Mahadev Prasad versus State of West Bengal, AIR 1954, Supreme Court, 724, wherein false representation by the accused with the dishonest intention is discussed at length. Another matter, Mubarak Ali Ahmed versus State. This is AIR 1957, Supreme Court 87, wherein again it has been discussed how the delivery of property in addition to deception and inducement is required, which has been discussed at length in section 415 itself. It has been clearly stated. So here to attract section 420, there has to be a delivery of property. Then there is this case of Parith Pillai versus State, AIR 1973, Supreme Court 326. So here also the discussion at length is that deception must be with the dishonest and fraudulent intent. If there is no intent, then section 420 cannot be attracted and therefore the person cannot be prosecuted under the same. Now, I would like to give another example. This is similar to one which was discussed in the case of Muthu Kumar versus State of Tamil Nadu, 1995, 1 Criminal Law Journal, 350. This is similar to the example if I were to go to a jeweler who's known to me, and since I have built this relation, now this jeweler is not aware that I am leaving the town for good. So I pick up some heavy jewelry and I tell him that I will give you installments, and I give him post-dated checks, knowing very well that those post-dated checks will not be encashed and will bounce because I am leaving the town for good and there is no balance in that account, whether I close it or let it be, and I cannot be traced. So the very fact that I induced the jeweler, knowing very well that these post-dated checks will bounce, will attract Section 420. But with the same example, I go to the jeweler, I buy jewelry, I give post-dated checks, 4 are encashed, but the fifth one bounces. Then there is a specific provision under the Negotiable Instruments Act, which is Section 138, that will be attracted and not cheating. Why? Because my intention at the outset was not to cheat. Now, for whatever be the reason, there is a shortfall in my account and the check has not been encashed and it has bounced. So it will not attract cheating. The very clear-cut demarcation is the intention. In the first instance, same example, my intention was to cheat. But in the second, my intention was not to cheat. So there, the specific provisions of Section 138 will be attracted and not of Section 420. Likewise, there is another example. If I were to give an example that there is an AGM of a company and all the shareholders are given a wrong statement by the board, including the auditors, of the status of the company. So that by itself, the intent is there to cheat the shareholders, to give a projection of the company doing good and inducing them to put in more money into the company. So that will attract Section 420. But if the AGM has certain, I would say there was no intention to cheat and all the reports were given wrong, but there were 1 or 2 omissions which were done by mistake, then specific provisions of the Company Act will be attracted. So the first and foremost ingredient, again and again, I'm repeating myself, is the intention. The intention to induce, the deception has to be there at the very outset. Without that basic ingredient, the offense of cheating is not made out and cannot be covered by any of the sections. Is there anything which needs some kind of a clarification, or anybody wants to ask me something? Because I feel we are all lawyers, and if I were to just go around reading the sections or reading the case law, that would become too boring, because you would feel that we can do that on our own also. I prefer an interaction so that I also know where I'm going wrong, or I can learn also. So if there is something which anybody wants to point out.
Okay. Tangachan, you're on mute. Tangachan, you're please unmute.
Madam, please explain about variable security also, which is also mentioned in section 420.
Yes. So
Can you?
when I'll just do that. So when I read section 420, just opening the section. Yes. So section 420 states whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person. So here it is clear cut that there
Yes.
has to be a delivery of property. Merely the intention to cheat is not sufficient. Or to make, alter, or destroy the whole or any part of a valuable security. Now, when we talk of valuable security, what is a valuable security? I gave the example of a passport. It may not be having pecuniary value, but is a valuable security. The minute I go in for multiple passports, the minute I go in for multiple passports, I'm attracting. Why? Because this is a valuable security. If there is inducement at the beginning, if there is just an impersonation, I get one passport done in the name of somebody else, that would attract section 417. But if I am getting multiple passports, why am I getting multiple passports with different names, different identities, is to use them at various occasions and thereby do a wrong act, thereby cheating the general public, thereby inducing the government, thereby cheating the government, thereby cheating the authorities. So thereby these sections will be attracted. Now, if I were to talk about another valuable is security. So there I had given the example of a check. Now, there is a check which is issued by a company. And there is a very interesting case. That case was that in Delhi, the telephone lines were operated by MTNL. Now, usually people don't write Mahanagar Telephone Nigam Limited. So it was MTNL. Now, one employee of the same MTNL company got hold of multiple checks. He was a South Indian and he wrote MTN Lingam. After the L, he wrote Lingam, which is a very common name down south. He got in touch with one of the bank employees. They opened a new account and he deposited all the checks over there into his account. Now, people had paid to the telephone line MTNL. But where did the checks go? They were converted, the valuable security was converted into his. So there, at the very inception, at the very beginning, the mindset was to cheat. So the valuable security was converted. There was a conversion. The checks were converted and the employee and the bank person who was hand in glove with the employee of the MTNL were hauled up. I'm forgetting the citation. I should have looked into it, but I'll just try and just see from my notes if I have something of that. But this is a real case. This is not an example. So very conveniently, the word was added. So this is a clear-cut case of cheating. The very premise, the very inception is of deception. Deception to procure a valuable security, convert it to his benefit and enrich. So the section was attracted.
C.K. Ramendran,
Ah,
please.
That if we go by some other examples, if I can give, like,
Madam, one
they
question
are,
from Ramachandran, C.K. Ramachandran. Yes.
I'm not able to
I
deal
think
that.
one citation, that is 1974 Criminal Law Journal. The other part is not clear.
1 second.
1974 Criminal Law Journal,
1 second, sir. Just let me see. That was given for which?
Discussing about the mens rea and dishonest fraudulently intention by explaining section 415.
1974 Criminal Law Journal.
Yes, I know.
That is
The page.
K.C. Thomas versus A. Varghese, 1974
Yes.
Criminal Law Journal, 207 Kerala. You
207
can,
Kerala.
yeah, there is another one you can note, which is Ranjit Pant versus State of Jharkhand. 203 Criminal Law Journal, 1736 Jharkhand. This talks of a clear-cut distinction between breach of contract and cheating. So there it is discussed at length in these different, because cheating per se also needs to be combined. Like there is always an overlapping of various other provisions of law. As I said, that there might be a provision which is covered under the company's law. There is a provision under section 138. Now, there is this case wherein I go for a hire and purchase of a vehicle. Now, I know very well I cannot afford it. Say I go to a BMW store and I have in my account 2 lakhs and I just pretend, okay, knowing very well my intention is to cheat. I pick up the car, take it, go out of the city, induce that person to part with the car on this premise that it's a hire and purchase, show false documents of income tax returns, show false bank balance accounts. The post-dated checks will never ever be encashed. The very fact that my intention was to pick up the car, take it to another state, change the number plate, sell it in the market for less, and get benefit out of it. So there, my intention at the very outset was to cheat. But then again, I go, I buy a car, few checks are encashed, 2-3 installments are not paid, the checks bounce. There, section 138 will be attracted because the intention was not to cheat. For similar offenses, the mens rea, again, I would repeat, the intention at the outset has to be there, which is, again, if I were to read section 415, it is very clear cut. Section 415 says, whoever by deceiving any person, that means the first line is, whoever by deceiving any person, fraudulently or dishonestly, induces the person so deceived to deliver any property. Now, when we talk of deliver any property, there section 420 is attractive.
Normally, this fraudulent intention and the dishonest intention can be identified or understand after some time. After some
Yes.
time, at the same
So-
moment, so at the same moment, we cannot say whether that person is dishonestly or fraudulently done all these things. So there is the crux. There is the crux. To find out or to understand the criminal intention or mens rea of the person is quite difficult. Almost all cases were failed or defeated in that aspect.
No, there I would say we need to then go through the illustrations, because I gave you the, obviously an offense is only realized, that offense has been committed at a later stage. But the mens rea aspect is very clear cut. I gave you same example, 2 situations. First example had the intention. Second example had no intention. The mens rea was missing. If we will just go through quickly the illustrations of the section 415, it will be more clear. The illustration A to the section 415 states, A by falsely pretending to be in civil service intentionally deceives Z and thus dishonestly induces Z to let him have credit goods for which he does not mean to pay. A cheats. I just had given an example that I pretend to be a bureaucrat, an IS officer, and I go to the local grocery store and I pretend I've just moved in here. So it's similar to the illustration which is given to the section. Now, the section B of the illustration is A, by putting a counterfeit mark on an article, intentionally deceives Z into a belief that this article was made by a certain celebrated manufacturer, and thus dishonestly induces Z to buy and pay for the article. A cheats. If I were to give an example to this, that we all wear denims and jeans. Now you go to the local store and you want to buy a pair of jeans. You go around searching and the man knows that you're looking for something which is better for good money. So he tells you that, see, excuse me, I have this designer brand Levi and I will give you these jeans, but there is only one pair in your size and I've kept it on the side. But if you are interested, I'll give it to you at a concessional rate because you're looking for something nice. And the shopkeeper knows that this is not a real and an original Levi branded jean. He has just procured the same brand from the local market and put it on the local jeans. Now, this example clearly is in sync with the illustration. It says that counterfeit mark on an article. Now, what that shopkeeper has done is he has taken a Levi brand, fixed it on a local jean and tried to part it off as a branded Levi jean, thereby inducing that customer to buy that pair at a lesser price than is available in the Levi original brand store. But is he buying an original brand? No. He is buying a fake, counterfeit brand name. But he is going back home happy with this belief that for a lesser price, he has picked up a branded pair. So there, the intention of the shopkeeper was to cheat. From the very outset, he knew the counterfeit, the brand name is fake. If we go to the third illustration, sorry. I'm sorry.
Madam, please continue.
Yeah, okay. Then we go to the third illustration. A, by exhibiting to Z a false sample of an article, intentionally deceives Z into believing that the article corresponds with the sample and thereby dishonestly induces Z to buy and pay for the article. A cheats. Now here, the example which I can just think of is that ladies in the group would definitely understand that I go to a jeweler and the jeweler says he's got some special stock of diamonds with him and he shows a big size solitaire that, okay, get a ring. And I get induced into buying that solitaire. I say, but are you sure it is for this much? He says, I'm giving you at a concessional rate because I picked it up from the market at a concessional rate. So since you are a regular customer, you take it. I say, I want to get it verified. He says, get it verified. I go outside, I get it tested, I get it verified, and I'm very happy because it's a real diamond and I'm very happy with the price. I go back and I say, okay, convert it into a ring. I go back home with a peace in my mind that I've got the diamond verified that it is pure diamond. The jeweler, on the other hand, picks up a local stone, which is a mesocyte, which is not diamond, which is no value. It is not even 1,000th of the value of real diamond, pure diamond. So the mesocyte, which is almost similar to the pure diamond, he fixes it in the ring and gives it to me. So the intention of the jeweler from the outset was to cheat me. It is not that it has happened by error. He showed me something. The sample which he showed was real. He induced me into buying, but what he gave me was fake. So there, that example befits the illustration C. If we go further to the illustration D, A, by tendering in payment for an article, a bill on a house, which A keeps no money, and by which A expects that the bill will be dishonored, intentionally deceives Z, and thereby dishonestly induces Z to deliver the article, intending not to pay for it.
Yes. Please switch off your audio, please.
That
Yes.
was a nice song. I was actually enjoying. I stopped reading. Oh, I did not understand the meaning of the words, but the music was making me my head go like this. I was bobbing my head with the music. Yeah.
Okay.
If I were to just repeat the illustration D, since we seem to have missed it with the music. A, by tendering in payment for an article, a bill on a house with which A keeps no money, and by which A expects that the bill will be dishonored, intentionally deceives Z, and thereby dishonestly induces Z to deliver the article, intending not to pay for it. A cheats. Now, if offhand, if I were to just consider an example which were to come to my mind for this illustration, I would say that I go to an exhibition, I like a painting exhibition, I go to an exhibition, pick up a painting, ask him to deliver it at this particular address, and the payment will be made. So the painter says, no, that's okay. You give me your address, I will come and take the payment, but you take this painting because otherwise I will have to say no to many people. I have no intention to pay. I have no intention at all. So I'm just taking it away, taking the receipt that, okay, this is the amount which is payable, but I have no intention to pay. I keep no money. So I have no intention to pay. So I'm cheating that person. The person has already delivered the good. Further, the diamond example is here. E. A, by play. This is illustration E. So A, by pledging as diamonds article, which he knows are not diamonds, intentionally deceives Z and thereby dishonestly induces Z to lend money. A cheats. So here it is lending about money. So I would say that I'm in need of some funds. So I go to a money lender and say, okay, these are my diamond bangles. You please keep this and give me 1 lakh of rupees. Now, the person knows me and he says, are you sure this is diamond? And I say, okay, you can verify. And since the person knows that I'm pretty well off and I must be wearing diamonds only, so that person is induced into giving me 1 lakh rupees for those bangles which have no value, which may be in the market for 200 rupees. But I induced him that these are real diamond bangles worth 2 lakhs. So you give me 1 lakh. So I made that money lender part with his money, pretending that I'm giving him as security diamond bangles, whereas my intention was to cheat. So it is not that my intention, the mens rea was there from the beginning only. As I repeat, that mens rea is the main crux. Then
Okay,
if we go
okay.
further.
Okay, Mr. Ajay Kumar, you
Yes,
want to ask?
yes. Madam, can you hear me?
Yes, sir, I
Yeah.
can. The rest of the illustrations you can read yourself.
In one matter, police charged an offence under section 419 and 420 together.
Okay.
Whether it will stand together, is there any legal bar of charging 419 and 420 together in one matter?
So what was, you'll have to give me the details.
It was a misappropriation of fund by a
So
government office.
So 419 is for what? 419 is for personation.
Impersonation.
Right? So that
Yeah.
person would have definitely personated himself under the criminal jurisprudence. If we were to see, then there are multiple times that there are various offenses with various punishments, but only the one which is the most grave, that punishment is the one which is given, though it is mentioned in that. So that person has not only misappropriated, that means the valuable security, there has been exchange of property, but he has also personated as somebody else. So because of the personation, section 419, 416 is there, which is governed by section 419. Now, because of that personation, 419 has been attracted, but the punishment will be only under section 420 because 420 is specific. It is that there has been since you said that in that case there was misappropriation. So there was some property which has changed hands, a valuable property. So
Okay.
obviously the person will be, yes.
Okay. Okay. Okay.
Mohanan, please unmute yourself, Mohanan. Yes, please unmute yourself. No, still you are muted. Please unmute. Yes,
Okay.
yes. Okay. Now yes.
Madam, one question.
Yes, please.
Suppose a man promised to marry a lady and thereby
Real?
obtaining
Sorry,
a
I'm not
man.
able to.
Yes, a man promised to marry a lady. A man
Yes.
promised to marry a lady, and thereby obtaining money and gold ornaments from her, and appropriated by him. Subsequently, his family members seriously opposed that marriage, and he could not perform the marriage. Whether his act will amount to cheating?
We have
There
discussed cheating.
there
What
is
do
a
you
pro.
think?
There,
What do you
there is
think?
a
Will
pro.
it attract? Now,
That is
we have discussed cheating. No, I'm just asking you. See, you yourself have answered this, that there is this man who proposed to the lady. That means
and
they were in
Yes.
love, they were in a relationship.
Yes.
The intention was not to cheat, but his parents opposed the marriage. So is this
yes.
a case of
Exactly.
cheating? It is not a case of cheating. It is merely a case of things not happening because they were not destined to be. So if that man is an honorable man, then he would return the security back, the valuable security which is in his possession, the gold and the jewelry, he'll return to the lady. If he is
That
not,
was not returned.
so that was not
That is not returning.
he's not returning. So then there, if at all,
Yes.
it will be a
Yes.
case of 417 to be punished. It will be a
In
minor offense.
406.
It will not be 420 because at the outset, same example, let's say that there is this lady who is very well off, very rich, and the man, he charms her and gets her involved, and then he takes away the gold and the jewelry saying that I need it for my business, and then he leaves her. The intention from the very beginning was to induce the woman into this relationship to part with the gold and her assets. So there, 101% that man will be prosecuted for cheating. There are so many matters in which cases have been filed under 376 where two people, they cohabit, where the man promises
Yes,
marriage,
exactly.
induces the woman, they cohabit, and then he leaves. But every case does not attract 376. Now there was this case wherein the woman repeatedly was getting pregnant, was getting abortions. 3 times it happened. Obviously, 3 times if it has happened, then there is a consent. Then she is not being lured. So the minute the consent comes into place, cheating aspect goes away. So there is no cheating.
And suppose someone borrows money from the bank and makes
Yes.
a single payment, suppose makes single payments.
Yes.
Suppose whether 420 will attract.
No, the intention has to be seen that when that money was taken from the bank, whether the intention was not to pay or there were reasons and occasions which came into being that prevented the payment. Now let's take the current situation. We are in COVID times. We all have taken, almost 80% of the population would have taken loans. Why a moratorium was granted by even the RBI and the banks was to enable all of us to not feel restless with our EMIs. I mean, there is no intention to cheat the bank, but our financial constraints prevented us to making the payment. So we cannot be liable for prosecution under section for the cheating sections. But then there is this person who in the month of March itself had taken a loan just before the COVID time, but had no intention to pay, not a single repayment. The intention was to take the loan and then just let it be. So there, despite the moratorium, after the moratorium period is over, once the EMI start, he is still not going to pay. So the cheating aspect has begun from the very outset. So, but where the person borrows loan from the bank, makes one payment, then there will be a civil suit for recovery. Then that will be a civil wrong. A criminal wrong is different from a civil wrong. For a criminal wrong to be attracted, the mindset, from the inception, the mens rea has to be there, that I have to cheat. A, B, C, she has to cheat X, Y, Z. So that aspect makes it a criminal wrong. Civil wrong will not attract. There, the bank can definitely go in for recovery of its money and other various whatever are the loan repayment schedule and whatever are the terms. They can go for. It's not that they are not left with any legal redressal to their grievance, but it is not a criminal wrong.
Jagadabai.
Am I audible? Am I audible?
Yes, ma'am.
Yes.
Yes. As you said, it is a civil wrong. If somebody borrows money, returns a part of it, and after dividing payment and eloping somewhere else.
Okay.
Then also civil, it will be a civil wrong.
No, not necessarily. Not necessarily. Here, at the outset, that's where the overlapping section 417 and 420 come into play. Now, here is this person who took the money from you and paid a few, returned a little bit of it, but later on developed this mindset that she doesn't need the money. She's so well off. It's okay if I don't pay her the balance. She's not going to be at a loss. So the cheating thought came at that point of time. So there, section 417 will be applicable. It's a simple cheating. Simple cheating vis-a-vis the graver cheating of under 420. So we have to. It's a very thin line, but with examples we can see. If the person had taken money from you and had no intention to pay, no intention at all, then at the outset only, the minute he took the loan, the cheating had begun because there was no intention to pay. But then in the example you give, the cheating aspect came at a later stage, that I can afford to keep it. She doesn't need the money. She's well off. So what happens if I don't pay? So my mind, so that his mind changed later. So it will attract 417. Cheating is there, but it will attract 417, not 420.
If he enters into an agreement to pay it within a stipulated time and evades the payment, then also the cheating will.
No, then you are talking of a promissory note. There is a promissory note whereby that person takes money, promises to pay within a specific time, pays part of it, but does not pay the balance, then you have a legal recourse under the civil law.
But the payment made is before entering into that agreement.
Sorry? No, it will be simultaneously. No, you would make the payment at the time of entering into a promissory note.
No, it was actually the facts of the case is that a lady's father passed away. He gave a loan to his niece while he was undergoing some treatment for cancer. During that period, he paid in 7 installments 1,38,000 rupees.
Okay.
But for the balance amount after the death of this man, he made a agreement with his daughter.
Okay.
And thereafter he eloped somewhere.
Okay.
And not making the payment of his so that she has to move by criminal complaint is made by her.
Okay. So so if I understand your example, that this man, let's say took a loan of 5 lakhs from Mr. A.
Yes.
Now Mr. X has taken loan of 5 lakhs from A.
Yes.
Mr. and while he is alive, X pays back 1,38,000 out of the 5 lakhs.
Yes.
Say let's make it 140, it's easier to speak. So 150 he pays to Mr. A and 350 is the balance.
Yes.
Meanwhile, Mr. A suffers
away
from cancer and passed away. Now his daughter is aware that there is 3,50,000 which this man has to pay me.
Yes, it was a bank transaction.
Whatever it be. So X enters into a contract with A's daughter to make the payment of 3,50,000. So with this is a fresh contract. And in the fresh contract, he had no intention to pay because A has passed away. So he says, why should I pay to his daughter? So he enters into the contract with this mindset not to pay. The intention has already begun not to pay.
Yes.
So you have answered the question yourself, that the intention when he enters into a fresh contract is not to pay and to elope. That why should I pay her the 3,50,000? That man is dead. So the cheating is already there. So obviously it will attract criminal prosecution.
That's right. So that 420 can be attracted already.
Yes.
Can I ask you one question?
Please.
Yes.
I would feel honored if with my little knowledge, if I'm able to clear your doubts, I would feel very, very honored. Please.
Okay.
You already touched upon these points. Now my question is, the finance companies engaged in gold loan business and also taking fixed deposits. Initially, it was perfectly okay. There was no mens rea. Subsequently, they misappropriated and they have taken away the money and all other things. In that case, the 400 Bs will attract or not?
आप खुद ही जवाब दे रहे हैं, आप खुद ही जवाब दे रहे हैं कि पहले चीटिंग नहीं थी, बाद में मिसअप्रोप्रिएट हो गया. The question is self-reflective. You answer me this question. आपका जो question है, आप खुद कह रहे हैं कि पहले there was no intention to cheat. So the money and gold was taken. Later on, it was misappropriated.
I asked this question because in Kerala, this is a very big scam is going on. That's why I asked.
Muthoot Finance?
Popular Finance.
Popular Finance.
So what do they actually do, sir? If you can just give me a bit of it. Like they take your gold.
Received investments.
No, their investments. They have taken 5 lakhs and every month they are giving this interest. So it went on for 10 years, 8 years. So people have got to
Sahara case is coming up in
Yes.
Kerala
Yes,
now.
yes,
Yeah.
yes, yes.
So that is what Mr. Subroto Roy did. He
Yes. Yes.
took money from like each and every poor person, started
Yes.
giving earlier on some kind of interest on their deposits, and
Yes.
later on it was like he started enriching himself.
Yes.
So
Yes.
it does attract cheating. It is because the mindset was to cheat. It is inducing you to part off with your valuable property and asset. When the cheating begins is not important. The day I start the scheme,
Yes.
my mindset is to cheat. That is important.
But
The
initially,
timing is not important.
it was not. It was not there in the beginning.
For you are saying, but the plan was to induce you people. The plan was there from the very beginning that once you people get used to this finance company, they have built their reputation. Then once the kitty becomes big enough, then they will stop paying and they can just keep the money. You remember there were so many cases, especially in Maharashtra. It had started a chit fund company opened.
Exactly.
The chit fund company used to take money from people. Once it became very popular and more people started investing, it just vanished with the money. So obviously the mens rea was at the time of opening the office of chit fund that we have to lure people. We have to induce people. There is a clear-cut deception which is at play to induce people that we will get more refunds for your money. And then once they are induced, they have caused wrongful loss to somebody. So that definitely attracts section 420.
Thank you.
So the inducement, different methodology adopted by different person for inducing the people
Yes.
has a wide and important role while discussing about 420. So
Yes,
regarding
because
that aspect,
please continue.
aspect, I think several judgment has delivered by Honorable High Court and different Supreme Court and different
Yes,
High Courts.
yes.
So
The
an elaborate
intention.
discussion with respect to the different mode of inducement is very essential to understand section 415 to 420.
I gave the citation of Mahadev. If you've noted it, if
Yes.
you want, I can just check it out for you again.
That is
Mahadev Prasad versus State of West Bengal. The dishonest intention. Then in Mubarak Ali case, the not only the dishonest intention, but also to induce the person to give the property. I think Mr. Sankachan would have noted the citation.
citation I had noted, but the name of the parties I didn't note.
One second.
Citation and I had noted.
I will just read it out. Mahadev Prasad versus State of West Bengal, AIR, 1954.
724.
Yes, Supreme Court 724.
724.
Then there is Mubarak Ali Ahmed versus State.
57 Supreme Court 87.
Yes.
What I submit that we have to see different method of inducement adopted by different cheaters to the people. We have to see that. Then only we can got an elaborate sky of section 415 to 420.
Your
That's
complaint
what I
also
said,
such a pleadings.
That it's so generic. People use the word 420 without realizing the implication. If it is 420 or 417, everybody is termed cheater. 420.
Cheaters.
So very
Cheating has differed.
Yes.
the drafting very careful.
Drafting
Otherwise,
from the very
sometimes it is not attractive.
No,
very
we have to see like just if we say under criminal jurisprudence, if we were to go beyond the concept of cheating, the difference between murder and culpable homicide.
Yes.
Death occurs in both the cases.
Yes.
but the mens rea, the intention,
Intention.
that makes the world of difference.
Gee.
The different between, otherwise there was no need for murder. If murder is there, where was the need for culpable homicide? But there it is causing bodily damage to such extent, but the
Okay.
intention is not. But in murder, there is a clear-cut intention to just go and murder.
Okay, ma'am.
Like
Okay.
it's like I have a gun in my hand and I point it towards somebody and I shoot. My intention is to kill. But if there is a scuffle and between two people and the gun belongs to that person, but in the scuffle between two people, the
Accident.
gun belongs to that person and he only gets shot.
Yes.
And there is no grave and sudden provocation. Both are fighting for no rhyme or reason. So I will not be covered under private defense. I will not be covered under grave and sudden provocation. Why? Because we are willingly fighting and we have got into this scuffle. So it will definitely, maybe not with the shot, maybe something falls on the head of that person, he will die, or maybe I pick up something and throw it at that person in a fit of anger. And I know that this can cause the death. So there the culpable homicide aspect will come, which is being discussed at length these days on the media in Sushant Singh Rajput's case.
Yeah, Rajput case.
So anything else, if I can...
I think Ravi Shankar Prasad case, madam. It is CBI versus Ravi Shankar Prasad.
Yes.
That was a very good example to understand the intention part, I think.
It is like, you know, a detail. It is a detailed setup.
Case. There was no loss to the bank, but at the same time, it was released to the companies and it was repaid. Even then, the Supreme Court held that section for
420.
Yeah.
That's what, exactly. That's what there was an inducement. There was an inducement.
Yes.
When the inducement aspect, whether, as I said, the cheating is not necessarily the property need not have a pecuniary value.
Yeah.
The inducement is such that the property is not only pecuniary. That's why I gave the example of passport. There can be an example where I go and there are so many times that people ask me, are you our additional Solicitor General, Ms. Pinky Anand, are you related to her? The minute I said, yes, I'm cheating. Why? Because I'm not related to her. Just because of sharing a surname does not make me that way. Justice A.S. Anand, our late Honorable Justice A.S. Anand, the Chief Justice of India. So once I was there in a conference and Justice Lahoti happened to be there. So he said, are you? I said, sir, no, I'm not. So he said, what? How do you know what am I going to ask? I said, sir, I presume that you're going to ask me, are you related to Justice A.S. Anand? So he said, yes, I was going to ask you that only. So I said, no, sir, but I do get a kick by telling people that he's my uncle sitting up there. But that is in jest. That is just in joke. But if I were to say, yes, sir, he's related to me, what am I doing? I am cheating. I am trying to project my importance to gain some kind of a benefit, which may not be pecuniary. Maybe Justice Lahoti might have referred, okay, she's the niece of the Chief Justice. There the intention comes.
So behind every promise, we must be aware that there may be an element of cheating. So you have to very, very vigilant regarding that aspect.
They're making promises.
Every promise. Every promise by every
Advocate
person.
Boban.
It's a promise which men make usually when they are in the courtship, that I will get you the stars and the moon. and all they get is Scotch Brite and soap to wash utensils.
Yes, sir. Sir, hello.
Yeah.
Can I audible?
Yes.
Highly informative, sir. No further doubts or questions. very pleasant presentation. Thank you, madam.
Thank you
Okay,
so
Boban.
much.
Okay, Boban.
Thank you very much. Thank you. Thank you very much for being such patient and nice audience and allowing me to just share whatever little I have my insight into the subject. And again, I would thank Tankan Chandi for such a nice time schedule and very nice session. And so thankful that you all have asked me questions. I would have actually, siesta time, I might have slept. I always keep a big mug of tea with me so I don't sleep.
Leena Chachi, do you want to ask any questions? Leena Jayasurin. And Amarjot Bajaj is there.
Good evening. Good evening.
It's a very informative and very with a very pleasant presentation also. You are so beautiful also.
I will take it as a compliment. Thank you so much.
And your class is like you, it was very attractive. And thank you so much.
Thank you. Thank you. You've really boosted my ego and I'm going to gain a few more kilos.
Okay.
You are from God's own country, so you are all beautiful people. Kerala is known to be God's own country, so
Okay, thank you.
you're all angels.
Oh, thank you.
So, if there are any questions more, I think we can conclude the session now.
VP Mohan is ready for a Thanksgiving.
Vote of thanks.
Vote of thanks.
I
Okay,
thank
Mohan.
you all. I thank you all rather.
Okay.
Yes.
Good.
ഞാനാണോ
Yes, yes.
അതെയാ good evening to everybody. Today we have got a very good class with respect to the subject of cheating. It was highly informative to all the persons who participate in this matter. I express my grateful thanks to Madam for taking such an endeavor in this matter. I also thank all the persons who participated in this matter. Thank you everybody once again.
Okay, thank you. I think now let us conclude this session.
Pleasant
Thank you so much.
Thank you, madam.
Thank you, ma'am.
Thank you so much. Thank you.
Mr. Tangachan, invite Madam to Kerala for a
Yes,
visit.
I have already invited her.
I would love to be. I would love to come there. Let the COVID time be over, then definitely I will be there.
Expect a good time.
Okay.
Yes.
Okay, let us
God
keep
will
it.
be kind.
Yes. Let us keep